Hello and welcome to this lecture on the law of partnership. In this lecture, we seek to understand different partnership relationships, how we can be able to enter into business through the partnership engagement. So we are going to be seeing the duties of partners. We are also going to be seeing what is a partnership deed, the contents of a partnership deed, and why the law of partnership has been established so that it governs how we continually relate as partners within our business establishment. So we begin by noting that when we talk about partnership, it is all about a relationship which subsists, or we can also use exists, between two or more persons. And these persons also, we are noting that they need to be carrying on business in common. And also they need to have a purpose of making profit. Yeah, so between two or more persons, and the reason they're coming together is to be able to carry on a business in common and with a view of making profit. Then we also note that the partnership is key because it's going to provide a framework for forming, managing, and dissolving partnership. We're also going to be discussing a very important subtopic on terms of, or in terms of, the dissolution of partnership. How does a partnership engagement come to an end? So moving forward, we look at the elements of a partnership. Every partnership has a number of elements. The first one is it has two or more persons. That simply means that there must be at least two or more persons involved. We have mentioned that on our definition. Then it also involves carrying on a business. So when we are talking about a business here, we are looking at trade. We are looking at the element of a commercial activity taking place. And then there needs to be something that is being done in common. So the business needs to be joined, or the partnership formation needs to have a management that is joint, or we work collectively as partnership within the establishment. And then finally, as we said on our definition also, the key objective or the main aim that we need to have is to be able to make profit. And once we make profit, we can now be able to share the profit among the partners. Now, we have people that can never be called partners. It is a presumption that all individuals that are working together are partners. But in law, that is not necessarily the case. For example, an exemption as to who can be called a partner is our subheading. So number one, when we have the repayment of a debt, and we are noting that if a person receives a share of profits as repayment for a loan or debt, they are not a partner. So once you have received your share of profits, and or also you are receiving a share in terms of payment of a loan or a debt, then whoever is paying you, you may not necessarily be a partner or in any of the partnership engagement. Remuneration to an employee who is paid a share of profit as part of their salary or bonus is not considered a partner. So as you watch this video, probably you are an employee in a particular organization. That moment where you receive a salary does not mean that you are in a partnership engagement with your employer. They are simply paying you for the services that you have rendered to his or her organization. Then the other one is annuity to a retired partner or a family member. And we are noting once we have a retired partner or a deceased partner, family may receive an annuity. An annuity is borrowed from the word annual, so it is amount paid once a year, or a share of profit as a settlement, without being a current partner. We are going to see people cease to become partners, for example, when they retire, but they could still be able to be holding shares within the partnership engagement. Even though they are retired from the partnership, they would still continue to enjoy these profits or a certain share from their investment. But remember, they have retired, so we cannot call them a partner anymore, even though they are enjoying some benefits. And then also we have the payment to a seller or a business. When someone sells a business and agrees to be paid through a share of profits, that alone does not make them a partner in that particular business. A very important discussion here, we are going to be looking at the difference between a company and partnership. And the first one is in terms of a company has a separate legal entity from its owners in shareholders. And we usually, when we are talking about separate legal entity, we usually give reasons as to why a company has separate legal entity. And we say, number one, it can, once a company has been incorporated and has a separate legal entity, we say that it can sue and be sued, it can hire and fire, and it can enter into businesses and so on and so forth. So that makes it stand on its own. When you are talking about it is a separate legal entity, the company, the name of the company and the owners of the company are two distinct individuals. And on the opposite side, on the side of partnership, it is not a separate legal entity. Partners, we are noting that they are personally liable for the business debts. And then we also note that under company, it is formed under the Companies Act. And the opposite of that, partnership is governed by the Partnership Act. In terms of the membership, in terms of the number of people that can form companies, for private companies, we have between 1 and 50 members. And for public companies, we have a minimum of 7 and no set maximum. And once we say that there are no set maximum, even when it comes to the sale of shares, which you are going to be seeing in the last point, it is an open space. You can do it anytime that you feel like, as long as you're a shareholder in a public limited company. But what happens when you are in partnership? Any transfer of shares, you have to consult your partners. Now, in terms of number, the partnership has a minimum of 2 and a maximum usually 20. And then members have limited liability on the side of company. They only lose what they invested. Now, there is the element of limited and unlimited liability. Yeah, so it is further expounded here that when we talk about limited liability, in case of debt and we want to wind up, then we can only lose what we invested. But we are seeing on the side of partnership, they have unlimited liability unless it's a limited partnership. We are going to be seeing that at the end of our discussion on this lecture. So unlimited liability means in case we want to bring our partnership to an end and we have debt that we have not paid. Unlimited liability means if we sell what we have invested together and is not enough, then unlimited liability means we can come into partners' private assets and be able to sell and liquidate so that we can be able to pay our debts. On the side of the company, it is managed by the directors on behalf of the shareholders. On the side of the partnership, in terms of the other difference, is that it is managed directly by the partners. And then finally is shares can be transferred, especially in public companies. There is that emphasis there. Actually, in public companies, we usually say that shares are freely transferable. And then we note on the side of partnership is that a partner cannot transfer their interest without the consent of others. So you have to consent. You have to request or ask the other partners to allow you to make a transfer. But in a public limited company, it is just a decision. You just wake up and make the transfer. Nobody is going to ask you. Now, moving forward, we are going to be looking at the formation of partnership. And we are noting that it is formed when two or more agree to run a business together. And the aim is making profit. Now, for formation of partnership, we have a very, very important document we refer to as the partnership deed. And we note that when we talk about a deed, it is a legal document that outlines the rights, the duties, responsibilities, and obligations of each partner involved in a partnership business. So when we talk about a partnership deed, I presume you have heard about what we call a title deed. It is an evidence that you own a particular piece of land. So when we talk about a partnership deed, it is a document that is going to show that partners have agreed to enter into a partnership agreement. So we also know that it serves as a formal agreement between the partners. And then also it is going to help be able to prevent misunderstandings or disputes. We are going to be seeing the contents of the partnership deed, and we are going to have a lot of misunderstandings about how we share profit, who does what in the partnership. But the deed clearly outlines that, and it makes it easy for each partner to be able to cooperate. So that is our next discussion, the contents of a partnership deed. Number one is the name of the firm. So the name of the firm should be captured in the document. Number two, name and addresses of the partners. Who are these people? What are their addresses? The nature of business, when we talk about the nature of business, is what kind of activity or business are you dealing with? That should be clearly stated. Remember, you cannot be able to transact on what we call illegalities or illegal activities. So that's where, as we come into partnership, we need to be able to state the nature of business. Then the principal place of business. This point emphasizes on the location of the business. So it is important to be able to mention the location. And then also capital contribution by each partner. How much is each partner bringing into the partnership? And then we also have the profit and loss sharing ratio. We also have what we call the duties and responsibilities of each partner. What are the partners expected to do? The reason why we introduced the one for profit and loss sharing ratio, it is one of the areas where we have experienced a lot of conflict among partners when it comes to the sharing of profit. So the moment it is clear in the document, then when those issues arise, then we can be able to have a document that we have a point of reference, and we can be able to know how or what we said around sharing of profit. The other one is duties and responsibilities of each partner. The other one is admission and retirement of partners. So at what point are we willing to bring in a new partner? At what point do we release somebody because they have retired? We put all that in writing in the partnership deed. Remember the issue of admission of a partner. As a partner, you cannot just go and come with your friend. You have to consult the partnership on and everybody in the partnership. So if they all approve, then we can go ahead and admit a new partner. The other one is dispute resolution procedures, if any. So when we have conflict, what are we going to do? We make that clear within the deed. Rules for dissolution of the partnership. So we put it in writing on how we intend to dissolve. Dissolving is winding up. For example, you can be able to capture on the reasons as to why, or what are some of the issues that will lead us to wind up the partnership. Duration of the partnership, we are going to be seeing one of the reasons as to when a partnership comes to an end is the completion of the time that you had agreed. So that is based on if the partnership had a duration set aside. And then we have the withdrawal of or withdrawings policy. So if somebody wants to withdraw maybe a part of their investment, what does the deed talk about? How does the deed clarify that issue? Then we are going to be understanding various duties of partners. For example, is duty to share profit and losses. And we are emphasizing that they must share profits and bear losses as agreed in the partnership deed. And then also duty to avoid conflict of interest. Remember, when you are having conflict of interest, you are doing something similar than like the partnership is doing. And that's why in the deed also, though we may not have mentioned it, you are going to find that we have something we call the need for you to declare your occupation. The reason why you are declaring occupation or what you do on the side is to be able to avoid conflict of interest. And then also the other one is duty to be liable for debts. And we are noting that each partner is liable for the debts and obligations of the business. So in partnership is more of all of us taking responsibility in running the business. If I get into a debt on behalf of the partnership, then that is not my debt. It is the debt of all partners. The other one is duty to act honestly and in good faith. And we are noting that all partners needs to be very honest and act in the best interest of the businesses and each other. And the other one is duty to share profits and losses. The other one is now on the rights of partners. Number one is right to indemnity. When we talk about indemnity, it's all about reimbursement. Sometimes you may go out and you're still on the activities of partnership and you spend an amount, and that's what we are saying, you need to be indemnified. If you have spent an amount on behalf of the partnership, then indemnity is about you getting a reimbursement of that amount. That is your right as a partner. The other one is right to interest on capital on loan. So if you agree that you're going to lend the partnership an amount, it is important that you are repaid back with interest. And the other one is right to share property. Partners jointly own partnership properties and have equal rights to use them or it for business purposes. And then the other one is right to a share of profits. So you have a right to enjoy whatever money that has been made based on what you agreed when we talked about the profit sharing ratio. It is your right to receive the amount. And then the other one is right to access books and records. We note that partners can inspect and copy the firm's financial and operational books. So access them, get to know the information in terms of the financials. How is the financial aspect of the firm? So you can be given the books and be able to inspect the books. We have something we refer also in partnership, what we call the implied authority of a partner. And we are saying when we talk about implied authority, it means that the authority which is not written or spoken, but it is assumed by law because of the partner's role in the firm. When we talk about implied, in the law of contract, we usually talk about types of contracts, where we talk about express contracts, and we also discuss what we call implied contracts. And we usually say express contracts are those contracts that are either in oral or in writing. On the contrary, we usually say implied. So express, they are oral or in writing, then implied, they are by the conduct of parties. So that's the same idea from implied kinds of contracts that we are borrowing from the law of contract and bringing into the law of partnership, to mean that a partner can engage in activities though they have not been written down or spoken that they are part of the partnership. But by the way they conduct themselves, it automatically becomes that they have exercised their authority on behalf of the partnership. And that's why we are noting a partner can, without prior approval from others, number one, buy goods the firm deals in. Let's say, for example, it is raw materials that we have exhausted. It is an implied authority, or it is a role that you have carried out when you now go and buy these goods. Remember, we have said as you do that, you are acting on behalf of of the partnership. The other one is sell goods belonging to the firm. That is extremely very, very important. Also receive payments and issue receipts. Hire employees for the business. The other one is borrowing money. And that is only when borrowing is a part of the usual business of the firm. And then finally is to be able to negotiate contracts related to the firm's business, or negotiate contracts related to the partnership. Now, in partnership also, as we move forward, we have what we call assignment of shares in partnership. And we are noting the Section 35 of the Partnership Act. Remember, we are also making reference to the Partnership Act, a law that has been enacted in Kenya. It now goes ahead and states that a partner may transfer their share in partnership to another individual. And that individual, we are noting that they are called the assignee. And this transfer can happen through a gift, it can happen through a sale, it can happen through a mortgage. And it is importantly to note that, however, the assignee does not have a right to. So even though you have become an assignee by the virtue that shares of another person have been transferred to you, that's why we are saying, however, there are things that you cannot do even though you have received those shares. Number one, you cannot take part in the management or running of the partnership affairs. So there is some form of restriction. And secondly, you cannot demand to access the partnership financial records or transactions. So that is very, very important. So shares can be assigned, but they come with restrictions. Restrictions in terms of your inability to participate in the management of the organization, restrictions in that you cannot be able to inspect financial records. Now, so the assignee, what is the assignee entitled to? We have said he cannot be able to take part in the running of the company, and we have also said that he cannot request or he cannot check on the financial records. So what is the assignee entitled to? That is what we are capturing here. Two things. Number one, to accept the profit statement as determined by the partners. That is number one. So whatever profit that has been determined, this person doesn't have an option rather than to accept. And the other one is to receive the portion of profits that corresponds to the assigned share. So that is very, very important. Liabilities of incoming partners. Yeah. We are noting that the liabilities of incoming partners, it refers to the legal responsibilities a new partner assumes upon joining an existing partnership. So they are liable to a number of things. Number A, liability for future debts. We know that an incoming partner is liable for debts and obligations incurred by the partnership after they join, unless agreed otherwise. And the other one is no liability for past debts. So when you come in and you find that the partnership already has debt, you cannot be personally held liable for those debts. And the reason is because they have been incurred before your admission as a new partner. The other one is capital contribution. They must, or these incoming partners must contribute capital as agreed, which becomes part of the partnership. And the other one is binding by acts of other partners. And we note the new partner is bound by actions taken by other partners in the ordinary course of business after they become a partner. Now, we also have those people that we call outgoing partners. Maybe, for example, somebody has retired. Somebody has felt that they are no longer fit to be part of the partnership. So, as outgoing partners, what are they liable to? The first one, it is liability for debts incurred before retirement. So, every debt that has been incurred before you leave, it is presumed that you are also part and parcel of that debt. The other one is right to share profits, and we are noting that it is in some cases if the outgoing partner's capital remains in the business. So you can be outgoing and still have the money that you invested still part of the business. That simply means you will be entitled to a share of the profits until it is paid back. And then the other one is continuing liability for acts done while a partner. And we know that they are still responsible for any acts or transactions that took place during their time as a partner. And finally, liability for future debts if no notice is given. And this we are capturing that if proper public notice of retirement is not given, this is presuming you just walked out, you never communicated. In case the partnership finds itself in debt and you did not provide an official communication that you have exited the partnership, you could be held liable for those debts. So that is the emphasis, that as you leave any partnership, then you need to officially communicate to the partners that are within the firm. A very, very important discussion on the dissolution of partnership. And when we are talking about dissolution, it's also what we call how does a partnership relationship come to an end? Number A is what we refer by agreement, and we know that the partners mutually agree to dissolve the partnership. And then the other one is by expiry of term. There's a place we mentioned that within the lecture. So if you came into the partnership for a fixed duration of time, once that time comes to an end, you can be able to wind up. And the other one is by completion of purpose. We note that if formed for a specific project or purpose, it dissolves once the goal is achieved. So, and the other one is by notice. In a partnership at will, any partner can dissolve it by giving a written notice to the rest of the partners. And then also very common dissolution method or way is by death or insolvency. And we are noting that the partnership is automatically dissolved if a partner dies or becomes bankrupt unless otherwise agreed. We could be, the reason why we are saying unless otherwise agreed, probably our partnership deed could be reading something different. Yeah. So maybe a clause, for example, upon death, this family member is nominated to continue to be part of the partnership or to be brought into the partnership as what we have just called incoming partners. As we wind up on the dissolution of partnership, we also can be able to wind up a partnership through a court order. And we are saying the court order or the court directive may be based on the following grounds. Number one is the partner's incapacity or mental illness. The court can also order the partnership to come to an end by misconduct by a partner or breach of an agreement. And finally is continuous losses making the business unprofitable. And then we have illegality of the business if the business becomes illegal. So that is based on the reasons that the business is carrying out activities that are not supported by the law of the land. That's what we are calling illegality of the business that the partnership is doing. We have in partnership what we call limited partnership. And we note that when we talk about a limited partner in a partnership, it is the person who contributes capital to the business, but that is something very important to note. They do not take part in its management. And also importantly to note that their liability is only limited to the amount of capital they have invested in the partnership. So these people that only put in money and they are not involved in their day-to-day running of the partnership, what are their rights? What are the rights of a limited partner? Number one is right to be able to share profits. So they are entitled to a share of profits as agreed in the partnership deed. Then they also have a right to access information. So limited partners can be able to inspect books and records of the partnership. And then they have a right to be informed about how the business or how the partnership is performing. Then they also have a right to assign interest. And by that we mean that they may be able to transfer or assign their partnership interest to another person. And this one is usually with the consent of other partners. So a Continuation still on the rights of a limited partner, so right to withdraw or retire. So they can withdraw their capital or retire according to their partnership agreement or with the consent. Of course, it is the consent with other partners. And then the other one is right to sue for wrongful acts. That simply means take legal action if the general partners act fraudulently. Yeah, so wrongful acts could be fraudulent activities, or also it could be the partners have violated the partnership agreement. And last but not least, we have what we call the right to return capital. So they are entitled to a return of their capital contribution after settling all debts during dissolution of the partnership. So what are their duties? What are they expected to do as limited partners? Number one, they have a duty not to interfere in the management of the partnership. There are those that want to just come in and bring chaos on a partnership that has been running appropriately. That could be a reason as to why you will be excused from the partnership, because you are not supposed to interfere. The other one is duty to contribute capital. They must fulfill their capital contribution obligations as stated in the agreement. And then the other one is duty of good faith. They are expected to act honestly and in good faith in dealings with the partnership. And as we wind up, is duty not to compete. So you are not, as a limited partner, even though you are not involved in the day-to-day running of the partnership, you cannot carry on competing businesses, and you do not have consent. And finally is duty to inform of changes. And this simply means that there should be a notice, or you should be able to give a notice of partnership changes that may affect their status. For example, a partner may have been declared bankrupt. So if that happens, then you need to communicate in writing to the fellow partners. So we have come to the end of this discussion on partnership. I believe that it is going to be of benefit to you. In case of any questions, you can drop an email in the email provided. Thank you so much.